Hello, welcome to Programme 2. Programme 2 is going to deal with how to handle a disciplinary hearing. That is a hearing relating to a difficult employee. Programme 1 on the MBS TV website dealt with that particular difficult employee. Might be worthwhile to go back there first to get the beginning of the story. Where has the story got to? Story's got to the position where the owner of the business, Frank Kilner, has gathered evidence with regard to Dave out there, the particular difficult employee, and he's thinking about getting to an end game here. He's been concerned about what has happened between Dave and staff, what has happened with customers. So what he's looking for now is a situation where we can hold a disciplinary hearing and he can then move from that to a dismissal. He wants it to be a fair dismissal. Shortly we'll be going to a meeting between Frank and Sarah Hall, solicitor, who will guide him through particular points that we'll come on to in a moment. What tends to happen in this situation, though, is a difficult employee who sees the game that is starting to develop by way of evidence investigation, disciplinary hearings, wants to avoid, wants to obstruct, wants to throw chairs in the way. And what's very important to establish a fair dismissal is that you have been able to hold a particular disciplinary interview, that in advance of it you have given information and evidence that is against the particular employee, and at that hearing you've given them an opportunity to respond to that. So it is key to move to a dismissal to be able to have had a sensible disciplinary hearing. What are the 3 points we're going to look at then? Sarah's going to look at the point about whether an employee, in this case Dave, who goes absent sick, perhaps not for genuine reasons, saying it's work-related stress, can he be forced to come to the particular hearing? Second point, what if he doesn't come despite efforts? Can we dismiss in his absence? And the third point, which is often used as an obstruction, is I want my lawyer at that hearing. So we'll be looking at the point as to whether, beyond a work colleague and a trade union representative, an employee is entitled to have a lawyer present, or perhaps their husband or wife. So we will now move to that particular meeting, and then we'll come back and look at a summary of those points later.
Hi Frank, thanks for coming in again. I got your email to say things have moved on somewhat with Dave. I think last time we met we were talking about the fact that we needed to do an investigation about the allegations that had been made against Dave.
That's right.
You've obviously moved on since then, but it looks like you've hit a bit of a stumbling block.
Yes. Dave has gone off sick after the first meeting we had with work-related stress. And he hasn't been seen since. You know, he just hasn't come back to work, although sick notes have come in. I've noticed on the sick note I've seen from the GP, it says he's not fit to attend any meetings, and it's unfair to put him under pressure.
Okay. That's on a fit note, is it?
Yeah, well, right. You know, I'm a bit surprised by seeing that written on a sick note, but there you are, we've got it. But as I said previously, we're just keen to move this along as soon as possible to whatever the next stage is we have to take. And I want to know, can we force him to attend a disciplinary hearing? Or can we just dismiss him in his absence because he's not cooperating with us? And the other issue we've got is that we had a note from him that he wants a solicitor or his wife to attend.
To a disciplinary hearing?
Yeah, and I couldn't understand that, you know, your wife or your solicitor. But his wife can be quite stroppy. We've had her at Christmas parties, you know, coming up to directors. So I wouldn't want his wife then. I don't see why we have to have a lawyer there.
Okay. So if we just take it one step at a time, the first issue obviously is he's off with work-related stress. Are you comfortable that the investigation part of the process is now complete and that we're ready to move it to a disciplinary hearing if we can get him there?
Yes, we've done everything you've told us to do. We've managed to get all the information together.
Right.
Bob's been quite good about that, and he's a very detailed bloke. So he's got all the witness statements. He's made recording of everything that he's had to do and the people he's spoken to. So in fact, he's compiled this wonderful dossier
right.
on Dave. But during the last investigation meeting, he just got up and walked out.
Right.
Fair enough, it was almost at the end, but Bob said he was surprised, and Bob thinks, this is Dave, that we've already made our mind up.
Right, okay. In terms of the period of absence now, are we talking about weeks or months that he's been off with?
Well, now, he's been off now for 3 weeks.
3 weeks, okay.
And that's our concern, that this is causing a hiatus now, and that he's doing this deliberately, just to stall matters.
I mean, it's certainly not unheard of where employees do try and use tactics to avoid going to a disciplinary hearing, but ultimately the hearing needs to take place. What you do have as well, however, is genuine cases of stress, and we have to be seen as the employer to be making sure you're making the right decision based on the facts rather than an assumption of the fact that Dave just doesn't want to be at the hearing. The way we get that information is through the medical experts, and I appreciate we've had so far a sick note, which is saying he can't come to this meeting. Have we had any discussions with Dave or his GP in terms of the disciplinary hearing, or is it just that document?
No, we've just had the sick note,
Okay.
because obviously Dave was aware, because Bob explained to him during the last meeting what was going to happen, because he said, what's going to happen next? So Bob explained it. I think that was a catalyst for him getting up and walking out.
No, that's fine. What we need to do is to try and get, as I say, the medical experts and ideally get confirmation that they say he can come to this hearing. And I know you might think that's unlikely given what's written on the sick note, but if you start asking the right questions of the GP, it's surprising how many times you can get the confirmation that although he's not fit enough to come to work, he could actually come to a hearing. And the way you put that in an appropriately worded letter is really just to explain that basically, while this disciplinary issue is hanging over him, his stress, his health issues aren't going to improve. We need to deal with this so that obviously as a business you can move on, but also so that Dave can move on as well and know what's going to happen. So as I say, the best first port of action is to write an appropriately worded letter to the GP, asking the right questions and putting our version, which is very much we think he should come to this disciplinary hearing so this matter can be dealt with and we can all move on. To encourage the GP to agree to that, what you can do is confirm that you're prepared to make some adjustments. So, for example, if Dave is worried about coming into the office to have the disciplinary hearing, because I know lots of people have been complaining about him,
Yes.
you might be feeling uncomfortable about that, you can arrange for the hearing to take place at a different venue.
Okay.
You know, you can book a room if you need to in a hotel, a conference room in a hotel, have that set up, and he might feel more comfortable in that environment rather than coming in here. There's other things you can do, obviously, in terms of having regular breaks during the disciplinary hearing, making sure he's got an appropriate representative with him, and we'll come on to that. But there is a good possibility that if we write it in the right way, we might get the GP on side. I appreciate that won't work in every case.
Okay.
What we then need to do is think about getting an independent doctor involved. And this is certainly something I've done in the past, where you get another medical expert involved and they speak to and communicate with the GP and they assess whether there has actually been a true assessment of whether Dave can attend this hearing or whether, in fact, the GP's just listened to what Dave has told him.
Okay.
And as I say, that can work if we can't get the GP to agree in the first case. And there's somebody I can put you in touch with if we need to do that.
Oh, that was going to be my question, Sarah. That'd be excellent if you could
No,
do that.
that's fine. What we need in both cases is Dave's consent. So he would have to consent to us either approaching his GP or getting an independent medical expert involved, because obviously we're talking about health issues here. We're talking about confidential information. Again, you might think, well, Dave's not going to agree to that, but what we can do, once again, is write the letter to Dave explaining why this is important and put it in such a way that he can see that this could be to his benefit and that it doesn't look good for him if he refuses this. But ultimately, he can refuse it. That would be his decision, and we'd spell that out to him, what his statutory rights are, but also what the impact could be if he says no.
Okay.
One of those impacts could, of course, be you decide to go ahead with a disciplinary hearing without him. So this might take a little bit of time in terms of the letters that we send to Dave to see if he is prepared to agree to it, because, as I say, you don't want to be putting pressure on him when he's off with stress, but you want to explain to him, first of all, what his statutory rights are about giving consent to get the medical information,
Yeah.
but on the other hand, what this could mean in practical terms if he doesn't agree to it. So we can manage that process.
Okay.
And then the next question you were asking is, could we dismiss him in his absence? Are you talking about now, or are you talking about in the future?
Well, it's now, because I think he may be wholly uncooperative, because I think this is just a ploy by him to stall everything, because I think he thinks we've already made our mind up and that he's going to go, and he's just trying to prolong the agony for us, because he knows the disruption it's causing to our business.
Yeah, yeah. And that is a factor that the tribunal would take into account, disruption to your business. So the tribunals don't expect you just to wait forever, and they don't expect you to just suddenly drop potential disciplinary actions if he can't come to the hearing. Unfortunately, there is no set guidance in terms of when it is appropriate to hold a hearing. So there's nothing which says if you wait 2 months, 3 months, it's then reasonable to hold the hearing. Because what the tribunal will do is take into account all of the circumstances. First of all, they'll see what steps have you taken to try and get him to the hearing. That's where the letters come into play. They'd also consider the medical side. So again, the medical reports are important. Have you done enough to find out what the true medical situation is? And obviously, if the medical information is supportive that Dave is genuinely ill with stress, that's part of the process we would have to be seen to be managing. But they'd also take into account the disruption to your business.
Yeah, because that's the problem with the directors at the moment. They can see the drop in income, the staff are unhappy, we have customers complaining who is handling, where's the accounts manager.
Okay.
And we're trying to put staff forward, but obviously they are not the accounts manager.
Yeah.
And it's causing a couple of problems within the team as well. And we're just trying to get everything back onto an even keel.
Yeah.
And that means if we have to cut Dave loose, we want to do that sooner rather than later.
Yeah. I mean, I can absolutely understand that. But on the other hand, what we have to deal with at the moment is the facts. And the facts at the moment are he's signed off with stress. And we're being told, don't put any more pressure on him. Which is why we're going to go through a process to see if that factual information changes as a result of the medical information we get through. Even if it doesn't, ultimately, as I say, you may well come to the point where you take the decision you have to proceed with this. If you do get to that point, it is important that you've given Dave every opportunity to be at that hearing. As I say, you've gone through the medical information. And then even if you decide we're going to go ahead without him, there's still steps you can take to put yourself in a better position. I'm not saying the tribunal would uphold a fair dismissal, because we'd need to know what stage you were at in the process, but the types of things you can do to show that you were a reasonable employer is things like making sure you've written to him in advance, given him the option, for example, of being at the end of the telephone.
Yeah.
You could also ask whether he wants to put in written submissions. So if you make it clear to him that if he doesn't turn up at the hearing, you will go ahead without him. This is the evidence you're relying on. This is the questions you would put to him. See if he'd put in the answers in a written form.
Okay, that's
so
fine.
At least you've got the information and you can be seen to be taking it into account at the disciplinary hearing. The other thing that you would do is obviously give him a right of appeal. So whatever decision you come to, whether it's a warning or whether it's a dismissal, you would clearly give him a right to appeal. So if he wanted to, he's still got another chance to turn up for a hearing. And again, if he's saying he can't turn up, you'd follow a similar process. If he does turn up, you take that opportunity and do it as a full rehearing. So he is asked the same questions, in effect, that he would have been asked first time round. So in some ways what you're doing is putting right the fact that he wasn't at that previous hearing.
Okay.
So we can manage that, and as I say, the letters are key, because that will show the process we're intending to follow without being seen to be too heavy-handed.
Okay.
Okay. The last issue you mentioned is an interesting one about Dave saying he either wants his wife or a solicitor there.
Yes. To me, wife and solicitor, two completely different people. If it being a union rep from some, I could understand that. But he said his wife or his solicitor. And the concern we've got here is that the wife would become very difficult. What rights has she got to say anything? Because we know how vulnerable she can be. Because we've all had experience, as I said, at one of the staff functions. The solicitor, is, well, what is he going to do? Because we're not legal people. Is he going to try and create something out of nothing at the hearing? And that's a concern the directors have, you know. So really, we're relying upon your advice as what we should do there.
I mean, I think you're right to raise it as an issue. I certainly don't think you should put yourself in a situation where you just agree it for an easy life, and in fact, you know, that has consequences. Yeah. If we go back to basics, his statutory right is to have a trade union representative there, which you mentioned. But I appreciate not everybody does have access to trade union representatives now. Or he can have a work colleague, and he can choose who he would want to have there. I suppose what we need to take into account in this case is he's got a lot of his colleagues complaining about him.
That's right.
But I think you did mention there's perhaps a few that are still on side.
There are 2 or 3 of his friends, and we know that he's still contacting them.
Right.
Because the cars have been seen outside his house by other staff.
Right.
So we know they're still contacting him, but I don't know whether they would feel a bit concerned about being at a hearing and being on his side. So we may have to give them some comfort, you know.
Yeah, absolutely. You know, if anybody approaches us or approaches anybody in the business, we need to make sure they're saying the right things.
Yeah.
Certainly not seen to be discouraging them from being there. But the other thing we have to take into account is, although his statutory right is just work colleague, trade union representative, because he's currently off with work-related stress, it could be argued that it would be reasonable in these circumstances to allow him to bring somebody else.
Okay.
The most obvious example is his wife. So a family member, somebody who he feels very comfortable with, somebody who he trusts to be there as his companion on the day. So I appreciate what you have said in terms of his wife, but actually agreeing to have his wife there might make the difference between him turning up to a disciplinary hearing and not. And it also shows that you're being reasonable as offering that as an adjustment, something different, because of these particular circumstances.
Okay. Would it be appropriate for you or someone to draft something as ground rules when we write to him, just so he knows what his or her rights are, to do anything at the meeting?
Yeah, absolutely. Well, the way to deal with it is either you could put it in writing before, or certainly at the very start of the meeting explain, because you know we don't expect them to know what their rights are or what their duties are. Explain how this is going to work in terms of the companion. The key point is that the companion's role is fairly limited. Certainly ACAS guidance is you should let them be involved as possible, but realistically they're not there to answer questions on Dave's behalf. They're just really there to put Dave's case. So if they want to, make certain arguments, make submissions, if they want to confer with Dave, and again, you're talking about somebody who's off with work-related stress, you'd give them that time to confer. But they're not there to answer the questions on Dave's behalf. He would still be there to do that, and you would certainly explain that to them so everybody understands how this hearing is going to work. In terms of whether you agree to a solicitor being present, as I say, I would go for the alternative option of agreeing for the wife. It wouldn't normally be advisable to have a solicitor there representing an employee. It's not a statutory right, but also this is an internal process. It's not a legal process. Ultimately, of course, if he was to bring a claim to a tribunal hearing, of course he can have a solicitor there, but this is an internal process. And I think the way you explain it to him is that it's not a legal process. You haven't got a solicitor present.
Yeah.
It wouldn't be appropriate for either side to have somebody there. But as I say, you're giving him the option, which hopefully we're now more comfortable with, of his wife.
Well, for my part, it's the lesser of two evils. I'd rather have the wife than the lawyer any day of the week. But it will be helpful, again, if you could provide us with a script for the meeting and just confirm what rights she has. And I think would be useful to let her know in advance. Yeah. So if she has any queries, she can then raise them with us and we can come back to you.
In advance. Absolutely. I mean, I appreciate that. We're still a little way from actually getting them at the disciplinary hearing. But these are all things we can word in and manage in terms of the process. So in terms of the next steps, obviously we need to deal with the medical situation. So if I was to send to you a letter, which you can send to Dave, explaining why we'd like his medical consent, would you then pick that up and...
Yes, because the key here for the business is to have a nice time path.
Yes.
Critical path analysis where we can say, okay, this is what we're going to do and we'd like to stick to it. So if you can lay down some some guidelines for us and say, well, look, this is the time frame.
Yeah.
Because the directors want, that's critical for them, because they want this issue resolving as soon as possible now.
I can understand that, as long as you explain to them that obviously, depending on the facts that come back in terms of the medical reports, we may have to look at that timeline again, but I can certainly give options in terms of the information we may get. Is that okay?
Well, that's been really helpful, Sarah, as ever.
Lovely. Thank you.
Okay, to summarise, first point, usually better to get someone to a particular hearing, but if there are medical problems, you can use their GP, you can use an independent doctor and try and manoeuvre them to that particular hearing, get them to see sense that it isn't going to go away, and it's better to get these things dealt with. Second point, if despite those efforts a person will not come to the hearing, if the evidence is strong enough, you can take a decision in their absence, and that decision could be to dismiss. It's not ideal, but if the facts dictate, then you could do that. Third point, in respect of a companion, usually it's employee, colleague, work colleague or trade union representative. Never allow a solicitor there unless the point that Sarah mentioned is present. I would say that if the wife wants to be there in these circumstances, especially because of the medical matters, allow the wife to be present. She could even help. Okay, that's the end of today. Goodbye.